Major breaking news out of the United States Supreme Court. As I predicted, Merrick Garland may have made a terrible mistake, and the price he has to pay may be starting now. Specifically, it turns out that the lawyers for Bryan Range have indeed agreed that his case involving the constitutionality of 18 U.S.C. 922 G1 dealing with nonviolent felons should be heard by the Supreme Court, which means we may have a Second Amendment case up there this term alongside with the Rahimi case, which is the case that Merrick Garland handpicked. But as I told you, things may not always work out for the Attorney General of the United States. Stay tuned. We're going to break this major breaking development down in one moment. Hey folks, I'm Mark Smith, host of the 4 Diner, proud American gun and constitutional attorney, member of the United States Supreme Court Bar, and author of Disarmed, What the Ukraine War Teaches Americans, and as it turns out, Israelis, about the right to bear arms. More on that down the road. But for today, major breaking news. The attorneys for Bryan Range have just filed a reply brief or a response brief to Merrick Garland's request that the Range case be granted certiorari by the U.S. Supreme Court. Just to jog your memories, we know about the Rahimi case, which is before the Supreme Court, oral argument to be occurring in early November. And that was the case involving a man who apparently, based on the court documents, abused his girlfriend, the mother of his child, I believe, and was subject to a domestic violence restraining order. He then subsequently possessed a gun during the pendency of that restraining order and was arrested and convicted under 18 U.S.C. 922 G8, which deals with domestic violence restraining orders as one aspect or one particular component involving a prohibited person. And as you know, because of the odious nature of the allegations and the charges against Zaki Rahimi, Merrick Garland rushed that case to the U.S. Supreme Court and got it granted cert in the spring, in June of 2022, with the oral argument in November. The other case that was up for, really was eligible for cert, was the Range case, which dealt with a set of facts much more favorable to the Second Amendment community. Specifically, Bryan Range, about 25 years ago, pled guilty to a misdemeanor charge for failing to disclose certain lawn mowing income on an application for public assistance. And this constituted a misdemeanor under Pennsylvania law. Nevertheless, the way the law was defined and the potential penalty that Bryan Range could have gotten for what he pled guilty to was over more than 2 years in prison. Even though Bryan Range never served a day in prison, even though Bryan Range was never considered violent, he was never considered dangerous, any of the above. Nevertheless, because of the nature of what he pled guilty to and because it had a potential sentence of more than two years, he was deemed a felon for the purposes of the federal statute 922 G1 that says that if you're a felon, as defined by federal law, you cannot possess a firearm. Much more favorable facts to the Second Amendment community, which is why Merrick Garland, despite running the Department of Justice, decided it was somehow more gamesmanship to advance the ball under 922 G8 because he doesn't care about justice. He doesn't care about the fundamental rights of Americans. He only cares about winning for the partisan hacks of the Democratic Party and his anti-gun boss and his bitterness that he sleeps with. Merrick Garland, you know, and I know, milquetoast moderate Merrick Garland, you know, is bitter that despite being nominated for the Supreme Court to replace Justice Scalia after he passed away by Barack Obama, was denied the ability to get on the court. And thank God that happened, because milquetoast moderate Merrick Garland, who we were told was a moderate, has been anything but as the Attorney General of the United States. Nevertheless, let us carry on. I predicted, of course, a couple weeks ago that when Merrick Garland sought cert in the Range case, having waited many months to do so, waiting until essentially the last possible day to do so to make sure he minimized the chances of the Supreme Court granting cert to the Range case over the Rahimi case, he finally sought cert. And now Range's lawyers have come back and says, we agree. Cert should be granted here and it should be heard alongside the Rahimi case. Now, the oral argument cannot occur because of the timing of this, But certainly, we can have multiple Second Amendment cases this term. One of the arguments that the attorneys for Bryan Range made in this case was that it is not unusual when you're dealing with other aspects of the Bill of Rights, the First Amendment, the Fourth Amendment, the Fifth Amendment, and so on. It's not unusual at all during a term of the Supreme Court, which begins the first Monday of October and ends in June of the following year. There's not unusual for there to be multiple cases involving a particular aspect of the Bill of Rights, like the First Amendment, the Fifth Amendment, the Eighth Amendment, whatever it is. And since we have historically only heard like a case involving the Second Amendment every several years, why not hear more than one Second Amendment case a year? And they did an excellent job explaining that unlike 922G8, which is heard, and they pointed out actually in the brief, and they do a nice job. Ready? They point out on page 13 of their brief, I'll put a link to it down below, that there are only 26 convictions under section 922G8 every year. That is less than one conviction per state per year. This is literally an important arrow in the quiver of American law enforcement. Of course, we understand that because dealing with domestic violence restraining orders is really a matter of local law enforcement and state law. And the fact that the feds got involved with this is really questionable, not only under the Second Amendment, but also under, among other things, like the Commerce Clause. How does Congress have the authority as a government of enumerated powers to stick their nose in to local law enforcement at this level? We'll see what the Supreme Court says. Nevertheless, they point out there's only 26 convictions under 922G8. In contrast, in the Range case, which deals with 922G1, felons in possession, they point out there are 7,600 convictions. 7,600 convictions per year. That's almost 300 times the number of cases over 922G8. And yet Merrick Garland, Milquetoast Merrick, went out there and says, oh, we need you to deal with 922G8 and Rahimi. We know why, because Rahimi appears to be an odious, scummy character, according to the pleadings, and Mr. Range appears to be an upstanding citizen who may have made a single mistake pleading guilty to a misdemeanor many, many years ago, many decades ago, with no sign of violence or anything in this background. We know why Merrick Garland did what he did. He was playing strategy. He was trying to play games. He was trying to game the system in favor of gun control. Well, that's fine if you work for Everytown for gun safety. It's fine if you're a lawyer for Michael Bloomberg, as far as I'm concerned. That's what good lawyers do. But when you're the Attorney General of the United States in charge of the Department of Justice, you are supposed to do justice. You're supposed to be fair and even-handed. You're not supposed to be a strategic partisan hack representing a political party with an anti-gun agenda. That's not how it's supposed to go down. Nevertheless, that's why Merrick Garland laser focused on an aspect of the federal law that was never enforced, because he thinks that is a better vehicle to destroy the Second Amendment and to destroy the Bruin methodology, which has given rise to more Second Amendment victories between June of 2022 and today than we saw in the whole decade plus between the Heller decision in 2008 and the Bruin decision in 2022, which is why Merrick Garland wants to use the Rahimi case to destroy the Bruin methodology and destroy the Second Amendment. But now there's a curveball with this Range case, because this is going to remind the Supreme Court, as they look at the situation and the facts of Range, that indeed there's other people that are involved outside of the context of the odiousness of Zaki Rahimi. So the question presented by the lawyers for Mr. Range are this: whether 18 U.S.C. 922G1, which generally prohibits firearm acquisition and possession by anyone who has been convicted of, quote, a crime punishable by imprisonment for a term exceeding 1 year, is subject to an as-applied Second Amendment challenge, and whether 18 U.S.C. 922G1 is unconstitutional as applied to respondent Bryan Range, who was convicted in 1995 of making a false statement to obtain government benefits. Remember Martha Stewart, this is the Martha Stewart question, who's never heard a fly, at least a fly that wasn't perhaps screwing with her fruit and vegetable garden, let's say, but she's never heard anything, and nevertheless she's lost her gun rights for life because she lied to the FBI. As a side note, I think the FBI is allowed to lie to you, but you can't lie to them. How's that fair? But that's for a different video and a different discussion. But let us carry on. The argument by Mr. Range as to why the court should hear cert. Remember, the issue here is Rahimi's already been granted certiorari. They're going to hear the case. They're hearing the case. They're going to hear oral argument in November. The question is whether or not they will grant cert and hear the Range case as well, which I think if they do grant cert for the Range case, this will be a very, very good sign for the Second Amendment. If they do not grant cert in the Range case and wait to decide Rahimi first, it will probably be more of a neutral sign. It won't be necessarily a good sign or a bad sign. It will be sort of a neutral sign because the normal protocol might be for them to hold the Range case, decide Rahimi, and then decide what to do with the Range next year. But again, if they grant cert to Range, it tells Americans that the Supreme Court wants to deal with this prohibited people and set the standard under Bruin, under 18 U.S.C. 922G for kind of all the different aspects of prohibited people in that federal gun control statute. Now, I want to remind all of you something else. Amy Coney Barrett is sitting on the U.S. Supreme Court, in my opinion, for one major reason. That is because she wrote a dissent when she was on the Court of Appeals in a case called Kanter versus Barr. Now, if you watch a lot of Fox News back in the day, you would have seen me talk a lot about this all over Fox News during Amy Coney Barrett's confirmation hearings and that battle. And I pointed out repeatedly that Kanter versus Barr, which dealt with the nonviolent felon question, was an opportunity for Amy Coney Barrett to demonstrate that she was fully committed to the right to keep and bear arms, and she more than demonstrated that by writing a dissent saying that Mr. Kanter, who was a nonviolent felon, had Second Amendment rights that could not be willy-nilly taken away, and that she applied the text and the history test of Heller. Remember, the Bruin test is really just the Heller test gussied up to make lower court inferior courts understand it in a sippy cup paint-by-numbers fashion. But the Bruin methodology is simply the Heller methodology, now called the Bruin methodology, but it's the same process. And that is exactly what Judge Amy Coney Barrett did before she sat on the Supreme Court when she's a federal Court of Appeals judge. She did exactly that and concluded that nonviolent felons had a right to keep and bear arms under the Second Amendment. It was that decision that made it clear she was good on the Second Amendment, and that helped her get elevated to the nomination by President Trump to the Supreme Court, where she replaced the late Ruth Bader Ginsburg. I think that is a good sign. I know there's some comments and criticisms about her. We're going to get to that in some other videos about what might be going on there, but I do not think Amy Coney Barrett is bad on the Second Amendment, but we will talk about that in another time, in another place, but I will address that in due course. But this gives rise to where we are now, and that is that the Range case is a nonviolent felony case in the same manner, in the same ilk as that Kanter versus Barr case that Amy Coney Barrett made her name, if you will, on as right in that powerful dissent in support of the Second Amendment. So I think there's a very good chance that the Supreme Court will grant cert in Range and will rule in favor of Range, in favor of the Second Amendment, in favor of Bryan Range, against Merrick Garland. And it's my prediction that if that were to occur, the justice that would write that opinion would be Amy Coney Barrett. Now, I know she's a little junior for a big decision like that, but given her record on this area, in this space with nonviolent felons, I'm guessing she might get the opinion assigned to her by Chief Justice John Roberts, but only time will tell. The first step is let's see if the Supreme Court agrees to hear this case and grant cert, which is what we should all be cheering for. And just to show you that the lawyers did indeed make the critical argument, this is what they said. They basically put it in the Supreme Court's face that indeed Merrick Garland played games with the odious Zachy Rahimi. This is what they wrote on page 32 of their decision. They said that whatever the reason for that, it is hard not to suspect it is because the government, Merrick Garland, views Mr. Rahimi as a much less sympathetic target for its arguments in favor of firearm prohibition than Bryan Range, a person who not even the government alleges is a danger to anyone. The government's position is incompatible with this Supreme Court's oft-repeated assurance that the Second Amendment does not enshrine a second-class right. So there you have it. The lawyers have specifically put in the court's face the fact that Merrick Garland is playing games by trying to push Rahimi and not Range. I think it's great that they did this on pages 32 and 33. Then they go on to make the point that I just made about how, indeed, it's not unusual for the court to hear multiple cases in a particular area of constitutional law. And here's what they write, quote, "It is commonplace for the court to hear more than one, sometimes many more than one, cases involving a single constitutional right per term. For example, this court heard 4 4 First Amendment cases in the 2003 term, and here's more than one such case almost every year, and he goes on to give other statistics. That's on page 33. Powerful point, I think, that again, it's not unusual in other constitutional law questions for the court to hear multiple cases involving, let's say, the First Amendment, and I think that's important for the court to be reminded of that here. So to summarize, I think the 4 reasons why the Supreme Court may want to hear the Range case is pretty clear. First, the Third Circuit Court of Appeals already ruled in favor of Bryan Range that he has a Second Amendment rights. That was over the objections of the Department of Justice. Anytime a federal court of appeals has held that a federal gun control statute or any federal statute is unconstitutional, that is usually a grant of cert. That's almost an automatic grant of certiorari because, again, a federal statute has been declared unconstitutional. Usually the Supreme Court likes to be responsible for the final say on such questions. And here the Third Circuit Court of Appeals out of Pennsylvania, Delaware, and New Jersey said that the 922G1 statute was not applicable and did not prevent Bryan Range from having a gun, given the Second Amendment. So basically, they declared part of that law unconstitutional. That alone justifies a grant of cert. Second of all, there is a circuit split on this issue. Although the Third Circuit said the nonviolent felons do not lose their Second Amendment rights, other courts have said otherwise on the Court of Appeals level. So you have a clear circuit split. And when you have half the country has one rule of law, and a different part of the country has a different rule of law under the same federal statute, that also increases dramatically the odds of the Supreme Court hearing that case. Third, obviously, we're dealing with a fundamental constitutional right, which is the Second Amendment's right to keep and bear arms. The Supreme Court has repeatedly said this is a fundamental right. In those cases, it's more likely that they're going to hear a case. And last but not least, there are thousands, like I said, there's like 7,600 convictions a year of people under Section 922G1. So 922G1 prosecutions are a huge deal in the federal criminal justice system. So thus, hearing this case and deciding what the Second Amendment means for 922G1 cases has a substantial real-world impact on the federal system. So for those 4 reasons, I think there's an excellent chance the Supreme Court is going to grant cert to the Range case, which again deals with the constitutionality of federal gun control statute 18 U.S.C. 922G1, felons in possession, and whether or not the Second Amendment cuts that back in any respect for Mr. Range or otherwise. All right, folks, we'll keep you apprised of this, but I think this is a big deal and good news for the Second Amendment community. We'll see what the Supreme Court does. We'll see if Merrick Garland gets away with his gamesmanship here or doesn't. We'll know a lot more in the next few months, and I will tell you what happens as soon as I hear. In the meantime, don't forget to subscribe to this channel, like these videos, circulate these videos, encourage people to watch the 4 Boxes Diner videos so they get smart and force multiply. Don't forget to follow me on Twitter or X at 4 Boxes Diner, and we will see you again soon here at the 4 Boxes Diner.
Orders up. Table 2A.